Hello and welcome to the Evershed Sutherland podcast on global freezing orders. In this episode, we are going to talk about freezing orders in Germany. My name is Joos Hellert. I'm a partner and head of the litigation and dispute management team of Evershed Sutherland in Germany.
And I am Agnieszka Feind, senior associate at the litigation and dispute management team in Munich.
So let's start it. Agnieszka, in which context are freezing orders typically used in Germany?
Freezing orders, in German Arrest, are mainly used in civil proceedings to temporarily secure assets. These measures ensure that assets are available to fulfill possible future court judgments. Typical areas of application comprise, firstly, securing monetary claims. A freezing order can be issued to ensure that the respondent does not dispose of assets needed to satisfy a monetary claim. Secondly, interim relief. These orders can also be used to preserve the status quo until a final judgment is made. And thirdly, protection against asset transfers. They are often issued without prior notice to the debtors to prevent them from hiding or disposing of assets. Yours, what are practical considerations around obtaining freezing orders? What do clients need to bear in mind when bringing them or facing them as respondents?
When seeking a freezing order in Germany, there are several practical considerations to bear in mind. First, proof of the claim. The applicant must prove a valid underlying monetary claim and show that there is a risk that the debtor will dissipate his assets, making enforcement difficult. Second, ex parte applications. Freezing orders are often granted without notifying the debtor in order to prevent them from moving assets once they learn of the application. Third, no security required. Unlike some other jurisdictions, Germany does not require the applicant to provide security. However, the applicant may be liable for damages if the freezing order is later found to be unjustified. Fourth, scope of assets. The order may cover all types of assets, including tangible, intangible, movable, and immovable property, both within and outside Germany.
Further considerations are timelines, legal costs, and post-order processes. So applications should be made promptly to avoid any arguments of delay, which could undermine the urgency and necessity of the order. While costs are normally borne by the respondent, if the order is granted, the applicant should be prepared to pay the initial legal costs of obtaining the order. Once the order has been granted, it must be served to the respondent, who may object to the order. Any objections will be considered at a hearing, and the decision based thereon may even be appealed with the Court of Appeal.
What are the practical considerations for third parties affected by freezing orders, Agnieszka?
There are several practical considerations for third parties. So the first one is the notification and compliance. Once notified of a freezing order, third parties such as banks or business partners must comply with the terms of the order to avoid legal consequences. This includes freezing the specified assets and preventing any transactions involving those assets. Another consideration is liability for non-compliance. Failure to comply with a freezing order may result in legal penalties, including fines or other sanctions. Third parties must take the order really seriously and act promptly. And another consideration is documentation and record keeping. Third parties should maintain thorough records of all actions taken in response to the freezing order. This documentation may be crucial if there are any disputes or legal proceedings relating to the order. Yes, let us talk about what other interim remedies are available in Germany, as well as when and how they are being used.
Sure, I like that. In Germany, in addition to freezing orders, there are also preliminary injunctions, in German language einstweilige Verfügung. A preliminary injunction in Germany is a temporary court order designed to provide immediate relief in urgent situations. It aims to maintain the status quo and prevent irreparable damage until a final decision can be made in the main proceedings.
Preliminary injunctions are typically used in situations where the applicant would suffer harm that cannot be adequately compensated by monetary damages if the injunction is not granted. The matter must be urgent, and waiting for a final decision would have to cause significant damage to the applicant.
The party seeking the injunction files an application with court and provides evidence to support its claims of irreparable damage, likelihood of success, and urgency. Once issued, the interim injunction must be enforced by serving it on the respondent within a certain period of time. It remains in force until the court makes a final decision in the main proceedings or until a specified date. Just to name some examples, a preliminary injunction is used, for example, in intellectual property cases to prevent ongoing infringement of patents, trademarks, or copyrights, in cases concerning claims for injunctive relief, or other cases in which the status quo needs to be secured quickly. In exceptional circumstances, an interim injunction may even be granted to secure future deliveries in a supply chain to avoid significant damage. Agnieszka, could you please explain to our listeners how clients who potentially face an interim injunction or a freezing order can protect themselves?
Of course. If a client fears that an interim injunction or a freezing order will be issued, they can have a so-called protective submission entered into the Central Electronic Register of Protective Submissions. A protective submission, in German Schutzschrift, is a preemptive statement of defense that is filed with the court to prevent an expected interim injunction or freezing order, or at least to force an oral hearing. The aim is to ensure that the court considers the opposing parties' arguments before issuing an interim injunction or freezing order. Joos, what are the trends and relevant geopolitical developments affecting freezing orders in Germany and connected areas of practice?
Very good question. Geopolitical tensions and sanctions, particularly those involving Russia and other countries, have led to an increase in the use of freezing orders to target assets linked to sanctioned individuals and entities. This has heightened the importance of compliance and due diligence for international businesses. Furthermore, technological advancements, including blockchain and digital currencies, pose new challenges for freezing orders. These technologies can facilitate the rapid transfer and concealment of assets, making it more difficult for authorities to track and freeze them.
So, if you discover you are subject to a freezing order, the most crucial action is to contact our experienced litigation and dispute management team immediately. We will advise and represent you, ensuring your best interests are always protected.
Thank you, Agnieszka, and to all of our listeners. Thank you very much for your attention and for tuning in to the Evershed-Sutherland podcast on global freezing orders, focusing this time on Germany. We hope you find this episode insightful.
And if you want to stay tuned and informed about new episodes, just follow Evershed-Sutherland on LinkedIn. You may also visit evershed-sutherland.com to sign up for our newsletters. Thank you and goodbye.
Goodbye.